Welcome back. I'm Lee Burgess from the Law School Toolbox and the Bar Exam Toolbox, and this is part 2 of our substantive spotlight on criminal law. Last time, we covered the elements of a crime, the homicide framework, and offenses. Today, we're venturing beyond murder to explore property crimes and inchoate offenses, the other side of criminal law that shows up constantly on the bar exam. So let's start with property crimes, the bread and butter of criminal law practice. Think about it. While homicide cases grab the headlines, property crimes make up the bulk of what most criminal lawyers handle day to day. They're like the common cold of criminal law, not as dramatic as a rare disease, but far more prevalent. So first up, larceny, the granddaddy of theft crimes. As we explored in our Listen and Learn episode on property crimes, larceny requires 1. A trespassory taking, 2. Carrying away, 3. Of personal property, 4. Of another, 5. With intent to permanently deprive the owner. It's basically taking something that isn't yours with the plan to keep it. That trespassory part just means you didn't have permission, like sneaking a cookie from the jar when mom said no. Robbery builds on larceny by adding 2 spicy ingredients. 1, the taking happens in the victim's presence, and 2, it's accomplished by force or threat of immediate harm. Think of robbery as larceny's more aggressive cousin. Not content with just taking your stuff, robbery wants to intimidate you in the process. If there's a dangerous weapon involved, we level up to armed robbery. Now, what if you lawfully possess the property first, but then decide to keep it? Well, that's embezzlement, the fraudulent conversion of property by someone who had lawful possession. It's like if your friend loans you the video game and you decide, I think I'll just keep this forever, except usually involving company funds or assets. The key distinction from larceny is that you initially had lawful possession. Let's not forget about burglary, the breaking and entering of a dwelling of another at night with the intent to commit a felony inside. Modern statutes have expanded this to include any structure, not just homes, any time, not just night, and often any crime, not just felonies. It's like the law started with a very specific recipe and then said, you know what, let's be more flexible with the ingredients. And then there's arson, the malicious burning of a dwelling of another. Like burglary, modern statutes have expanded this to include other structures and even personal property. The malicious part doesn't mean you have to be twirling your mustache while doing it, just that you intentionally set the fire or were outrageously reckless. Let's round out our property crime tour with false pretenses, getting title to property through an intentional false statement, receiving stolen property, possessing property you know is stolen with the intent to permanently deprive, and extortion, obtaining property through threat of future harm or exposure of information. These are like the supporting actors in the property crime movie. Not always the stars, but crucial to the plot. Now, let me let you in on a little secret. When analyzing property crimes on an exam, focus on what makes each one unique. For robbery, look for force or threats in the victim's presence. For embezzlement, check if the defendant had lawful possession first. For burglary, you need the entering of a structure with intent to commit a crime. For extortion, it's all about threats of future harm rather than immediate harm. Our Listen and Learn episode on property crimes walks through each of these distinctions with examples and hypos, so be sure to check that out for a deeper understanding. Now let's shift gears and talk about inchoate offenses, the almost crimes that punish conduct even when the target crime isn't completed. Think of these as the law saying, you don't get a free pass just because you failed at crime. So first up is attempt. As covered in our Listen and Learn episode on inchoate offenses, attempt requires 1. Specific intent to commit the target crime, and 2. An overt act beyond mere preparation. The tricky part is deciding when preparation crosses into attempt. It's like trying to pinpoint exactly when mixing ingredients becomes baking a cake. Most jurisdictions use the substantial step test. The defendant must take a substantial step towards completion that strongly corroborates their criminal intent. Now, here's the twist. attempt merges with the completed crime. So if you attempt murder and succeed, you're just charged with murder, not both attempt and murder. It's like only counting the touchdown, not the attempt to score. Next, solicitation. Requesting, encouraging, or demanding that another person commit a crime with the intent that they actually do it. Remember, the crime is complete once the request is made and received, even if the other person says, "No way." It's like asking someone to pick up a coffee for you. The asking is complete once they hear it, regardless of whether they actually get you coffee. And finally, conspiracy. The agreement between two or more people to commit a crime, plus, in most jurisdictions, an overt act in furtherance of the agreement. Unlike attempt, conspiracy doesn't merge with the completed crime. You can be guilty of both conspiracy to commit robbery and robbery. Double trouble. The really devious part of conspiracy is the Pinkerton rule. Each conspirator is liable for all reasonably foreseeable crimes committed by co-conspirators in the furtherance of the conspiracy. It's like being held responsible for what your study group members do when you're not around. So when you're tackling these inchoate offenses on an exam, remember these key points. Attempt requires specific intent and a substantial step. The line between preparation and attempt can be murky, so argue both sides. Conspiracy requires agreement plus usually an overt act. Withdrawal can be a defense to conspiracy, but it's hard to establish. For more practice with these concepts, dive into our Listen and Learn episode on inchoate offenses, where we work through realistic bar exam scenarios applying these principles. Now let's touch on defenses, because sometimes even when all elements of a crime are met, the defendant might have a valid excuse or justification. These are like the plot twists in your criminal law story. Our Listen and Learn episode on defenses to crime covers these in depth, but here's the highlight reel. Duress. I only did it because someone threatened me with imminent death or serious bodily harm. Insanity. Different jurisdictions use different tests. The McNaughton, the Model Penal Code, irresistible impulse, or Durham. Intoxication is only a defense to specific intent crimes if involuntary. Voluntary intoxication rarely works. Self-defense. You have to have a reasonable belief of imminent harm, proportional response, no duty to retreat in most cases. Remember, these defenses function differently depending on the crime. Some are perfect defenses, complete exoneration, while others are imperfect, just reducing the severity of the offense. When approaching a criminal law exam question, think about using this systematic approach. First, break down the crimes at issue. Then break down each element. Then apply the facts to each element, arguing both sides and any ambiguity that you find. 4, consider any defenses. And 5, don't forget about inchoate liability or accomplice liability. Criminal law is kind of like a puzzle. All the pieces need to fit perfectly for conviction. One missing element and the entire case falls apart. That's why prosecutors charge multiple crimes and variations. They're covering all their bases. Stay tuned for part 3, where we'll explore crimes against the person beyond homicide and tackle complex scenarios involving multiple defendants and causation issues. We'll dive into assault, battery, false imprisonment, kidnapping, and those tricky accomplice liability situations. Thank you for watching, and be sure to give us a like, leave a comment, or subscribe so you don't miss any future content.